contained areas that, within communities that we can get people to. I know the Enfield Legion presently has applied for funding for a generator. They're trying to have that as an emergency unit so that they can get people in there if there's an emergency, and usually weather-wise, that would require them, having to leave their homes and go to a place that's heated and where they can get meals and so on. And I have to applaud them, and I think the province is helping them with some of the funding on that, and I'm very pleased that they're willing to do that. But this has been an initiative by the Legion themselves to do this. There's lots of other legions who are not doing this. There's other communities who are not doing this, and probably don't have the wherewithal the resources to try to complete the other part that the province is not helping them with. And this is still a challenge for the Enfield Legion. But I want to say that I'd really like to see the province take the lead to ensure that these facilities are made available and are furbished to a point where we know that if anything happens, here's where we can put 2, 3, 4, 500 people, for a certain period. And I'm not sure why we, when the weather's nice, why we don't look at having those things prepared for impending disaster. I think that, if anybody had thought they were going to predict the ice storm in Quebec, where people were actually without power for months there, this is something that we should be thinking, because weather patterns are not all that predictable, and actually the Weather Service now is saying that this may be a milder winter. Well, a milder winter is probably one where you're going to get rain and freezing rain and more potential for ice and more potential for power outages if that was to actually be a repeat of the Quebec ice storm. So with those comments, Mr. Speaker, I have no problem with the present bill, but I do have a problem with what I see as our lack of preparedness for what's at some point going to be a fairly great disaster heading our way. So with those comments, I'll take my seat. Thank you, Mr. Speaker.
Thank you, member. I guess we'll now prepare to close debate, and I'll call on recognize the Minister of Emergency Measures.
Thank you, Mr. Speaker, and it's my pleasure to rise in the House this morning and make some concluding comments and remarks on Bill 243. This legislation is put forward to enhance existing legislation and to make it even more effective and to provide that assuredness to Nova Scotia that we are prepared as a province and coordinating with federal and municipal authorities as best that possibly can be achieved to protect our citizens in time of emergency or disaster, as well as to be prepared as much as is humanly possible and to warn our citizens when a disaster or emergency may be pending. The legislation does two major things, Mr. Speaker. It changes the name to Emergency Management Office, which more accurately reflects the role of EMO in coordinating provincial agencies, in coordinating with municipal agencies, as well as federal agencies and all the different volunteer organizations like the Red Cross who are involved in emergency preparedness and relief efforts. And I would be remiss, Mr. Speaker, if I did not point to that we now have an emergency plan with each of the 55 municipalities in Nova Scotia, and again, it comes back to that management role for EMO as well. Mr. Speaker, I think it's important to recognize the people and staff involved with EMO and the volunteers that the Senate Committee in Canada recognized this is the model for the country, and certainly as the federal government works at getting their house in order, we volunteer our model and, of course, our comments and services in helping them get their house in order and their emergency plans. The second thing this bill achieves, Mr. Speaker, is greater coordination on identification and documentation and certification for trained people of all trades responding in times of emergency crossing the U.S. border, and we're specifically referring to reciprocal agreements and aid that would come across from the Atlantic coast northeast of northeastern United States. Currently, there are problems with documentation, and this legislation is an attempt to ensure that there will be swift and easy passage of emergency vehicles. I might add the best example to exemplify this that I've heard was from our CEO at EMO, Craig McLaughlin, who used the example of if the Halifax explosion had occurred in this time frame, the doctors, nurses, and professionals who rushed to our aid from Boston by train would be held up at the border. So I think that shows why this is important and it's critical. Other measures are majorly housekeeping to improve efficiency and modern definition for the Act, Mr. Speaker. And I want to thank, before I conclude, the members opposite for their support of EMO and their insights. The one thing I certainly would offer to the member of Hants East, so that he has an opportunity to become more informed, I certainly would endeavor to supply him with a portable radio, and hopefully we can supply him with one that has the hand crank in case the power does go off, because obviously he's missing a number of the communications that occur with all forms of media on a regular basis, so we'll supply that as well to the member. And with those remarks, Mr. Speaker, it's my pleasure to move Bill 243 for second reading. Thank you.
Thank you, Minister. The motion is for second reading on Bill 243. Is the House ready for the question? The question's been called. Will all those in favor signify by saying aye? Aye. Those contrary say nay. Motion is carried.
Bill number 243, an act to amend Chapter 8 of the Acts of 1990, the Emergency Measures Act, and Chapter 376 of the Revised Statutes 1989, the Public Service Act.
Order that this bill now be referred to the Committee on Law Amendments. I'll now recognize the Government House Leader.
Mr. Speaker, with the concurrence of the House, I would ask that we revert the order of business presenting reports of committees.
Presenting reports on committees. Agreed.
On behalf of the Chairman of the Committee on Law Amendments, I'm directed to report the committee has met and considered the following bills. Bills number 222, an act to recover damages and health care costs from manufacturers of tobacco, and Bill number 228, an act to amend Chapter 12 of the Acts of 1993, the Social Workers Act. The committee recommends these bills to the favorable consideration of the House with certain amendments.
Thank you. Bills 222 and 228 be accepted with certain amendments. Referred to the Committee of the Whole House on bills. Okay, the Government House Leader.
Speaker, would you please call the order of business public bills for second reading?
Bills for second reading.
Mr. Speaker, would you please call Bill 244, the Enforcement of Canadian Judgments and Decrees Act. And Mr. Speaker, on behalf of the Minister of Justice, I move second reading of Bill 244.
Bill 244, recognize the member for Coal Harbour Eastern Passage.
Thank you, Mr. Speaker. I'm going to speak very briefly on this piece of legislation. This is what is also known in some circles as a Reciprocity Act. Ensures that judgments made in other parts of Canada against individuals that want to be enforced in Nova Scotia can be done with a fair bit of ease, mainly that the judgment, if it's done in another province, has to be brought here and in a perfunctory manner, pro forma manner, is dealt with in our courts and becomes an order of our court, Mr. Speaker. There are some changes, I understand, to this piece of legislation around specifically consumer goods. If there's a contract for purchase of consumer goods, that there's an opportunity, if someone feels that there's been a problem, they actually have to sue in Nova Scotia if the consumer is here in Nova Scotia, Mr. Speaker, which I think is good. It doesn't rely on them having to travel or mount a defense in another province before it can be brought back here in a pro forma manner, Mr. Speaker, which means they have to come here to Nova Scotia, do the lawsuit here, and I think that's good for Nova Scotian consumers. So, having said that, I'm looking forward to seeing at law amendments what other concerns or comments there may be before it comes back to this House, but at this stage, we're prepared to vote on the principle of the bill and move it forward to law amendments.
Thank you, member. Recognize the member for Annapolis.
Thank you, Mr. Speaker. Just to add a few comments on behalf of our Justice critic, we too is looking forward to seeing this go into law amendments, to have listen to the public come in and make submissions around the law. To add to the comments made by the honourable member just earlier, we also believe it's a good idea that judgments will take place in Nova Scotia and some of the other amendments that have taken place. So we do look forward to seeing this in law amendments, and look forward to having submissions. Thank you.
Thank you, member. We'll now recognize the Minister of Justice to close debate.
Thank you, Mr. Speaker. It's my pleasure to rise to close debate. I appreciate the support of both members who spoke on the bill, and we believe that these are valuable improvements to the bill, and in particular the provision that will protect Nova Scotia consumers, we believe will provide a level of flexibility that will not only allow commercial transactions to be enforced in Nova Scotia, but will also provide the appropriate level of protection to the public. So with that, Mr. Speaker, I'd move second reading of the bill.
The motion is for second reading on Bill 244. Is the House ready for the question? With all those in favor signify by saying aye. Those contrary say nay. The motion is carried.
Bill number 244, an act to amend Chapter 30 of the Acts of 2001, the Enforcement of Canadian Judgments and Decrees Act.
Order that this bill be now referred to the Committee on Law Amendments. I now recognize the Government House Leader.
Mr. Speaker, would you please call Bill number 246, the International Trusts Act?
Bill number 246, the International Trust Act. Recognize the Minister of Justice.
Thank you, Mr. Speaker. Mr. Speaker, this is a bill that would implement the Hague Convention signed by the Government of Canada relative to this matter. I think we would be the 8th Canadian province to pass such legislation, and it is one of these bills that is really designed to harmonize the law between countries and also obviously within Canada. So with that, Mr. Speaker, I'd move second reading.
I'll recognize the member from Halifax-Shabukto.
Well, thank you, Mr. Speaker. Indeed, as the Honourable the Minister says, there is a virtue in having uniformity on certain commercial matters, and insofar as the arrangements exist among states and among parties that would be looked to enforce certain kinds of contractual or semi-contractual arrangements. In this case, trusts, I don't think anyone has any objection to this. I only want to say that I never understood that there was a problem here. It was a bit of a surprise to me to see that this legislation had to come forward, especially to deal with trusts. I hadn't understood that there was any particular difficulty in coming forward. I've looked at the Hague Convention, which is appended to the bill and which is in effect made applicable in the province, to use the language of the bill. It's not clear to me that it changes something that wasn't the case before, but I'm certainly not objecting to the legislation. I want to clearly be understood that we're supporting it. I think that if there is some call for it, if there has been some difficulty, then indeed it's appropriate to tidy it up. If it's a question of anticipating and avoiding avoiding any problems, then this is also a virtuous step. Anyway, the Act is fairly straightforward, at least we hope, in its application. I suppose in the fullness of time we'll find out from the learned justices of the Supreme Court of Nova Scotia and perhaps at higher levels whether there are any difficulties in it, but I commend the Minister for having paid close attention to the proceedings of the negotiators of the Hague Convention and coming so promptly to us with this bill, and we will certainly support it.
Thank you, member. Recognize the member, the honourable member from Annapolis.
Thank you, Mr. Speaker. Just on behalf of our Justice Critic, I too also want to add our support of moving this forward to law amendments. And as said by the Minister, we are the 8th province to join on, and it is good to see uniformity across the country. So with that, a few remarks, I move.
Good Minister.
Thank you, member. We'll now recognize the Minister of Justice to close debate.
Thank you, Mr. Speaker. I appreciate the comments of the honourable members opposite, and like them, look forward to the bill going to Law Amendments Committee. With that, I move second reading. Mr. Speaker.
The motion is for second reading on Bill number 246. The motion is for second reading on Bill 246. Is the House ready for the question? With all those in favor signify by saying aye. Those against say nay. The motion is carried.
Bill number 246, an act to implement the Hague Convention on the law applicable to trusts and on their recognition.
Order that this bill now be referred to the Committee on Law Amendments. We'll now recognize the Government House Leader.
Yes, Mr. Speaker. I'm not too sure. I've got a mark on Bill 250, and I'm not too sure if there was some member that asked that we not proceed with Bill 250 today. Pardon? Monday, okay. Mr. Speaker, would you please call Bill 251, the Public Service Act?
The Bill 251, the Public Service Act. Okay, I'll recognize the Government House Leader.
Okay, Mr. Speaker, would you please, correction, would you please call Bill 249, the Enforcement of Court Orders Act, for second reading?
The motion is for second reading on the Enforcement of Court Orders, Bill 249.
Thank you, Mr. Speaker. Mr. Speaker, I'll rise briefly to speak to this bill. Yeah, that's right. I'd make sure the opposition are satisfied that we're proceeding with this bill today. Thank you. This bill does fundamentally two things, Mr. Speaker. The first thing that is done by this bill is to create an enforcement mechanism to encourage people who are in default of fines and other penalties, costs and the like that are owing to the province of Nova Scotia under federal legislation. And there is a difficulty that is developing in the criminal law of this country, and that is around the difficulty of enforcing those kind of court orders, because they are a court order to pay money. And it is becoming increasingly difficult to do so. And what this bill does is fundamentally ensures that that people respect those orders and that they pay the money that is required to be paid. And Mr. Speaker, we have heard from a lot of law enforcement officers that it is becoming an increasing problem that certain offenders seem to not respect court orders as a general type of instrument. And this is designed to, frankly, encourage the respect for those court orders and to ensure that people take the appropriate action.
Thank you very much.
I should also add, Mr. Speaker, that this is clearly not an attempt to put those people who are less fortunate in our society in a worse situation. Clearly, Mr. Speaker, the fine option program, which is the program which allows a person who has received a fine but feels that they cannot afford to pay that fine to elect into the fine option program, which allows them to do community service, in effect working off their fine as a debt owing to society by doing work beneficial to society in another way. So therefore, that whether or not people have the amount of ready cash or not, there is an option available. What we are talking about is that group of people who choose to flout the law altogether. And that is what this bill is designed to address. Not those people who cannot afford to pay, not those group of people who simply sometimes need more time. Because, Mr. Speaker, my experience as a lawyer has taught me that many times people go into court and they've come upon hard times, they need a little more time to pay the fine, and the courts are very, very willing to give people extensions on the time to pay their fines to enable them to take care of those fines. There is, however, a small minority of people who fall into the category of the people who intentionally choose not to do that. And criminal code offenses are the more serious offenses, and frankly are the ones primarily covered by this. And today, the issue of, for example, taking someone's driver's license or refusing to do business with them is available to, people today. The government does it with respect to motor vehicle offenses and those similar kinds of offenses. And so it seems appropriate that people who are in more serious conflict with the law should respect the law as well. I think, however, Mr. Speaker, another element of this bill, which is perhaps more important to innocent members of our society, is the provisions that allow for the creation of a scheme whereby, like maintenance enforcement, restitution orders can be enforced by the courts, or can be enhanced through the courts. Courts in this province, Mr. Speaker, oftentimes make restitution orders. That is an order where the perpetrator of a crime is ordered to pay a sum of money to the victim of the crime. And all too often, Mr. Speaker, the victims of that crime fail to receive any money from the perpetrator. And quite frankly, because of the civil enforcement methods that are available, there is no penalty whatsoever to someone who simply chooses not to pay the victim of crime. And Mr. Speaker, we believe that it is important that the victims of crime, that the state does what it can to assist the victims of the crime in receiving the money that they are lawfully owed by the perpetrator. And Mr. Speaker, this bill will also provide for such assistance to that victims of crime. And that is the second provision in this package, Mr. Speaker. And we would encourage members, all members on all sides of the House, to support this bill going forward to the Law Amendments Committee, because we believe, while it is not the complete answer to the problem, it is a step in the right direction. And with that, Mr. Speaker, I would move second reading.
Thank you, Mr. Minister. I'll recognize the member from Halifax-Shabakto.
Last weekend, Mr. Speaker, I saw a wonderful film. This film is called Cool Hand Luke. Friends of mine have recommended this film to me for years, and for some reason, I just never got the chance to see it before. And I understand from some of the cross-chat here that some other members have seen this film and perhaps have enjoyed it. It's a Paul Newman film. Paul Newman does a wonderful job as the chief character, the fella who is having trouble adjusting after World War II to his life, his civilian life. Here's what happens in this film. In the opening scene, we see Paul Newman as the Cool Hand Luke character, very drunk. He's out in the night time on the street in some small town. This would be 1946, 1947, somewhere in the southern United States. And he's very drunk, and he has in his hands a big pipe wrench. And what he's doing is he's taking the heads off of various parking meters up and down the streets in this town. He's got no reason for doing it. He's not stealing the money from the parking meters. He's just lost, doesn't know what to do with his life, and very drunk. And he's got the pipe wrench. There are the parking meters. He takes the heads off the parking meters, and he ends up in jail. The rest of the film follows him through his time for the next 2 years. He's given a 2-year sentence in this jail somewhere in the southern United States, where they all work on a road crew. Yep. Well, I want the Minister of Justice and members of this House to think about what would happen in contemporary Canada if some cool hand Luke character committed some act of public mischief that involved destruction of public property today. Because the thing about this bill, about Bill 249, is that it invites us to focus on enhancing the kinds of penalties that are going to be incurred by people. Now, I know the minister put it in terms of collection of the penalties, but you know what? We have to turn our minds to the particular choice that's being made in this bill, and we also have to understand it in a context. We have to understand it in the context of what other remedies are already available to the government under the criminal code or civilly. I mention the criminal code because, of course, this bill flows from the criminal code. There is a section in the code right now, section 734.5, that essentially sets the framework for the legislation that we have. What section 734.5 says is that when there is a conviction and a fine, that the province, if they're to be the payee of the fine, can in fact set up an additional step that would flow from this if they wish to. And so that's what this bill is all about. This bill says, let's take this power, the sentencing power, or this enforcement of sentencing power that's in the code, and now adopt it in our province. But what section 734.5 says is that the province can attempt to enforce this penalty through any license that the province has control over. And yet the focus here is just on one particular kind of license. We know that the province licenses people who go in for sport fishery. More seriously, they license people to teach, they license people to practice medicine, they license surveyors, they license optometrists, as we just saw in some of the bills that went through this House yesterday, and the list goes on. There are a huge number of licenses that are within the control of the province. A driver's license is not the only license that is in the control of the province. And before I look at why it is that perhaps this particular licensing scheme has been focused on by the minister, let's go back and think about what it is that's available to the Crown if it turns out that some kind of fine is determined to be appropriate for a violation of a criminal code offense. Because, of course, there are lots of circumstances in which this won't arise. If someone is sentenced to jail, we're not talking about this kind of offense or this kind of administrative step. We're only talking about instances where fines are imposed. And indeed, there are going to be lots of cases where that's the appropriate sentence, and the judge will deal with that. Well, the first, of course, is that the criminal code itself, already provides for civil enforcement. It is already a provision in section 734.6 of the Criminal Code of Canada that if a fine is imposed by the court for a criminal offense, they can treat that as a matter of a civil judgment and can move the same way as if there were a civil judgment against someone. In other words, there is that option to move as if it were a civil penalty already exists. The option exists there to sue somebody and to move in that way. So it's not as if the Crown has to sit around waiting upon the good graces of someone who's been convicted of a crime and fined to decide in their own good time and in their option whether they're going to pay or not. The Crown can sue and take that judgment and enforce that judgment. But that's only the start of it. Under the next section, section 734.7, it's possible, if someone is not paying their fine, to go for a warrant of committal. And indeed, this is a standard provision in the kinds of sentences that are imposed upon people if they are fines. In other words, it's an in default of payment clause. So what happens is that if a person doesn't pay their fine, the judge tells them at the time what will happen. In other words, you'll do jail time if you don't pay your fine. It's right there. It's already in the code, and it's a standard step taken by judges in our criminal courts every day when they fine people to say, if you don't pay your fine, you're going to go to jail for this amount of time in default of payment. It's right there in the criminal code, and it's used daily, all the time. Furthermore, and I get back to my Cool Hand Luke example from before, suppose there's been destruction of public property, that's the essence of the crime. You know what? At the time of sentencing, including the fine, the judge has the power under the criminal code to order restitution. That can be part of the sentence on top of the fine. In other words, you pay a fine for what you did because it breached the law, and furthermore, you've got to pay back, in the Cool Hand Luke example, the municipality for the damage done to the property, or perhaps a private person if there was damage done to them. That can be part of sentencing. And that is also subject to civil enforcement. It sort of bypasses the whole necessity of going to court for a civil action if there's been a criminal case in which the judge is prepared to do that. So these are examples. Furthermore, it gets tougher. The criminal code has sections that allow application to be made for forfeiture of property that's used in the commission of crime, or property that is in fact gained through criminal activity. So think about Cool Hand Luke again. He's sitting there with his pipe wrench. You know what? That pipe wrench can be forfeit to the Crown. That's possible under our criminal code right now. What I'm saying, and furthermore, if someone makes a lot of money doing certain kinds of criminal offenses, particularly the serious ones, and they buy real estate, that real estate can be forfeit to the Crown. If the Crown can show that they have used the proceeds of crime in order to buy that real estate. And it doesn't matter if the criminal puts it in their spouse's name. There are cases. The Part 12.2 of the Criminal Code lays out a whole array of steps that can be followed in order to take property that's the proceeds of crime. And there have been cases in which, in Canada, in which a criminal bought a condominium and put it in the name of their spouse, and that property was taken. It was forfeit to the Crown. What I'm saying here is that there is already a wide array of appropriate measures available under the criminal code to enforce fines and to impose penalties upon people. So why is it that we feel that we have to take this extra step? And if we are going to take this extra step, why do we focus on driver's licenses? Now, it's handy, but it doesn't focus on the examples I gave before of sports fishery, that's a license, of teaching license, medical license, surveyor's license, optometrist license. The reason I mention these is because driving is more than just a convenience in our society. And let's be clear that we're not talking here just about crimes that are somehow involving a motor vehicle. These are any crimes. These are any crimes under the criminal code that could have nothing to do with a motor vehicle. They could be, just like my Cool Hand Luke example from before, from the film, destruction, malicious destruction of public property, public mischief. And think about a taxi driver. At that point, we're going to be saying to the taxi driver, under this bill, you're fined, you'll go to jail if you don't pay your fine, we might confiscate your pipe wrench if you're taking the heads off of parking meters. We might confiscate other property. There's going to be a judgment against you. And now there's going to be the extra step, you're going to lose your livelihood, or until you pay it. Now I want people to be encouraged to pay their fines. I think this is right. But we're not taking away the livelihood of other people if they don't pay their fines. We're taking people, truck drivers, taxi drivers, Perhaps people who have to drive in order to get to their work, and perhaps they don't have a convenient way of going with other people to get there. We're really striking at the heart of what it is that they do to make a living in a way that we're not under this proposal for other people, for other forms of employment. Now, it's handy, and it will probably be very efficacious in some ways, but you have to wonder about why it is that we've chosen, the Honourable the Minister of Justice has chosen, to focus on this. I think that this has come up entirely too often. I wonder if there's been a blurring of the understanding, whether instead of just focusing on crimes that are somehow linked to the use of a motor vehicle, where perhaps it might be appropriate, and in expanding it to all the other crimes out there, I'm wondering whether we're taking what is not too broad a step. So I listened carefully to what the minister said. It seemed to me he spoke in general terms. It seemed to me he didn't really focus on exactly why it is that he thinks that this particular measure is one that is more appropriate than any other. I didn't hear him say that somehow the range of options for collecting fines under the criminal code was inadequate, that it wasn't working, that there were scofflaws who were failing to do this. If that's the case, then I'd like to hear it. I'd like to hear some details about this. We do know that some people don't pay their parking tickets. And we do know that we have a mechanism in place that directly deals with their licensing and their registration of their vehicles that doesn't allow them to continue to drive if they're not paying their parking fines. But we can understand that. That's purely under provincial laws. It's purely related to how they treat their motor vehicles, and it's clear that there's a one-on-one link. It doesn't have a link between driving and other kinds of criminal code offenses. And we haven't heard the minister make that linkage for us. So I'm happy to see this bill go on to law amendments for further scrutiny, but I have to say, I think it's important that the Honourable the Minister gives us a little bit more of context and explanation, either here or at committee, before we finally move ahead with this bill. I know the Minister is familiar with the sections of the criminal code that I outlined. I saw him nodding earlier when I referred to them, and I know he understands the context within which this bill has arisen. But if he wants to justify it, he should justify it, and not simply wave his arms around and say that here's a way to get tough on criminals. I know this is how he wants to brand himself and present himself, but we have to do something sensible. We have to think carefully about whether we're doing exactly the right thing. So Mr. Speaker, I look forward to seeing this bill proceed through the detailed scrutiny of the House that I know we'll all give it. But in this case in particular, I think that there's a real obligation on the Minister to come forward and tell us why he's chosen this particular mechanism for that particular end. Thanks very much for the opportunity to speak to this bill.
Recognize the honourable member for Annapolis.
Thank you, Mr. Speaker. I'll just say a few words. When you think you understand something, then you listen to lawyers talk, and then you become completely confused about everything. I think there has to be, there should be a law against that, having two speak in a row. Anyway, just to speak on this bill for a few moments around the fine options, I don't think anyone would argue the fact that when the courts impose fines, that there needs to be the proper mechanisms in place that we ensure that those that have been levied those fines have to pay them. The concerns, and one of the concerns that I have around this is the fact that we're not creating a two-tiered system. Not everybody is not paying those fines because they do not have the, because they just opposed to what the courts have said. They're not paying those fines for obvious reasons of not having the money. And to suggest that there's another way to put a heavier hammer on them by taking their license and all of a sudden they're going to manage that money come forward. I listened to the Minister of Justice who said that there was the fine options program in place, and I look forward to exploring that on my own to see what that is like. And when we get an opportunity to see community members come forward and do law amendments to speak on this bill, it will be interesting. The other concern that I have is, and I share that with the member who spoke previous, is around the driver's license. I would argue, and I would submit sound like a lawyer, I would submit that people who do not pay the fines is based on the fact that they just do not have the money, and the fact that we are going to become heavy-handed and remove their driver's license to run the risk of their employment, and which in turn would impede their ability to pay that fine. So, Mr. Speaker, we as a caucus do support moving this into law amendments. We look forward to the general public coming in and making some submissions on this. And so with that few remarks, we move.
I recognize the Government House Leader to close debate on Bill 249.
Mr. Speaker, on behalf of the Minister of Justice, I move second reading of Bill 249.
The motion is for second reading of Bill 249. House ready for the question? Would all those in favor signify by saying aye? Contrary minded? Nay. Motion's carried.
Bill number 249, an act to assist in the enforcement of court orders.
Order this bill be referred to the Committee on Law Amendments. Recognize the Government House Leader.
Okay, Mr. Speaker, I intend to call Bill 251, the Public Service Act, for second reading, unless there is the opposition would wish to defer that act. Okay. Mr. Speaker, would you please call Bill 254, the Motor Vehicle Act.
Bill number 254, the Motor Vehicle Act.
Mr. Speaker, I move second reading of Bill 254. Bill 254, Mr. Speaker, consists of two amendments, or two major amendments to the Act. Mr. Speaker, the first change, Mr. Speaker, deals with the interlock system, a system which has been adopted by 8 provinces now that we are in the process of adopting. Will be the 8th province. Prince Edward Island is following as well later on in the year. Mr. Speaker, this has been an item that's been before the province for quite some time, about 2 years actually. We've been considering the interlock program, and we delayed bringing in an act last year and earlier this year simply because, Mr. Speaker, we hadn't received all the answers to the questions that we had with regard to the program. For instance, in some jurisdictions it's compulsory, in other jurisdictions it's not compulsory, it's by choice. Mr. Speaker, we are going into the by choice regime simply because of the fact that at the present time the driving while impaired is a criminal offense, and it automatically carries a 1-year suspension of your driver's privilege. However, the law itself allows that after a period of 3 months that a person may reinstate their license by applying for an interlock system. Mr. Speaker, if they apply to the courts to utilize the interlock provision, they can then proceed to have that device installed in their vehicle, Mr. Speaker, which will permit them to drive the vehicle providing that they do not imbibe any alcohol. It has zero tolerance, the actual equipment itself. The equipment costs approximately $1,200 to $1,500, somewhere in that range, to have it installed in the vehicle, to have the readings taken on the device at periodic intervals, and then to have it removed from the vehicle. The second part of this amendment, Mr. Speaker, deals with the matter of speeding, and it deals with speeding in spaces that are restricted at the present time. This further increases the restriction by doubling the fines for speeding in those particular locations. Those 2 locations, Mr. Speaker, are school zones and those areas where there is a temporary workplace on the highway. Mr. Speaker, I'm sure most members are familiar with, if they drive at any time in the U.S. or in the province of Quebec, with these large signs that advise motorists that if they exceed the speed limit in a workplace, double fines exist. And Mr. Speaker, that would be the same as the type of signage which we will employ in the province of Nova Scotia. So, Mr. Speaker, with those few words and also adding that this program is endorsed by MAD, I would move second reading.
Thank you. I'll recognize the honourable member for Timberley Prospect.
Thank you, Mr. Speaker, and I look forward to making a few comments on this particular piece of legislation. The part of the legislation, of course, which is of particular interest, and I would say some expertise, of course, is the speeding in school zones. But before I turn to that topic, I want to clarify, and maybe sometime during the process, if we're clarifying this ignition, interlock, and monitoring program, I have some questions, and I know we'll get through this as we go into law amendments, and it's something, of course, that works, but there's always ways around it. And the questions that come to my mind when we first discussed this at our caucus was, of course, that it's if the person who is in this particular situation and has been charged and found guilty for drinking and driving, and on the vehicles that are under his or her possession in their home, in their driveway, in their garage, this particular monitoring program is put in place. But what kind of provision is it if for some reason this person is, and I use the word with some reserve, stupid enough to borrow his buddy's vehicle or a neighbor's vehicle, and that he then proceeds to drive although he is in this monitoring program? And I'd be interested in what other jurisdictions and how they handle that, because that's, after all, a problem. We know, and I have heard of cases in certain parts of our province where we deal with people who've been caught numerous times, 6 and 7 times, because of driving under the influence, been charged, and for one reason or another are still, and I use the word again with reserve, stupid enough to get behind the wheel of a vehicle again when they were in such a state. But I would like to draw our attention, the House's attention, to the speeding instructions in this revision to the Motor Vehicle Act. And I want to compliment the ministers involved, because the leader of the official opposition in a private member's bill a number of years ago introduced a private member's bill dealing with the fact of speeding in temporary work areas. And that private member's bill, as members from the opposition well know, generally go nowhere. But here we are in this particular piece of legislation. It has been followed up on. And one of the most efficient and, I think, effective advertisements that I've seen when it comes to the Department of Transportation, and I see the minister opposite, and I want to compliment him on that very progressive way of advertising dangers in temporary work areas, is that this is my workplace. And sometimes one of the workers interviewed says sometimes they're going so fast through a work area they take the hats right off our head. That, after all, is one, along with that great feather duster ad when that weather comes, that's very effective advertising and highlights the fact that this is their workplace, and because of what is happening, it's important to instruct Nova Scotians that they should be slowing down, and if they don't, they will face the consequences, of course, which will mean doubled fines. And I compliment the minister on responding to that piece of suggestion, which was, of course, brought forward earlier by the member from Cole Harbour. I want to turn to the issue of speeding in school zones. And I think it's appropriate that we recognize a member of the third party who has been very outspoken on this particular piece of legislation. On her own piece of legislation, the member from Halifax Clayton Park, and she's going to have the opportunity, I would imagine, to make a few comments on this piece of legislation. And of course, the key thing is, of course, to educate and identify on those school signs that, and they're very good signs, those fluorescent signs, they stick out. But now we have to have an addendum on those signs, appropriately placed, that if you're caught speeding in a school zone, you're going to pay double the fine. And so I asked the minister and his staff to look very carefully at some kind of suggestion when it comes to that particular way of dealing with informing the public. And I want to point out a very good idea in another province. Manitoba, school boards, and I point that out to the minister, and I know I'm talking the principle of the bill here, not specifically, but school boards in Manitoba make available to individual school principals those signs that you can put up beside the road. And I see the Minister of Education looking at me was to do this. There are principals who will contact an appropriate school board in Manitoba And they'll say, I'm having a problem with speeding and going by my school. I want one of those notified signs that says, that blinks at you as you're going by. You're going 60 in a school zone, okay? And some school principals very proudly stand out there. They have it for a period of a week, and they have it for a Monday to Friday, and they stand out there with the gun, if that's the appropriate term, and it would be, after all, a very public position to have a school teacher in, a school principal in, and they point that gun at the speed gun now. They point that speed gun at people who are rushing by on their way to work, or if they're rushing home, and that radar gun will then come up with the fact that this person is speeding. And you can reserve those signs. They're moved around through various schools by boards in the province. It's very well received. And I think that it's an idea that perhaps we should be looking at. You could reserve it for certain peak times. I know when school first starts in particular, it's a crucial time when people are involved in going to and from their place of work in a regular habit. And it's the summertime, of course, and we don't have to obey the school signs because the kids are not there. It's one of those things that would really be useful in enforcing the fact you're in a school zone and you should be slowing down. In fact, that habit comes to me so often that, for example, if you notice schools that are used on Saturday, schools are used on Sunday in certain situations by community groups. The first reaction is when you're coming near a school zone, just slow down, no matter what day of the week it is, no matter what time of the day it is. And of course, this suggestion that the fines are going to be doubled will hopefully be an incentive for drivers in Nova Scotia to make very sure that they are going to pay attention to these signs, or they will suffer the consequences. And so with those comments, I plan to share my time as we come towards, from what I understand, the hour of adjournment today. I would like to turn if I may, those are my comments, and I know the member from Halifax-Clayton Park has some comments also.
Thank you, and I'll recognize the member for Halifax-Clayton Park.
Thank you. Thank you, Mr. Speaker. It gives me a lot of pleasure to rise today and say a few words on Bill 254, which was introduced this week by the Minister of Transportation and Public Works. There are two key clauses, as has been noted. The first one relating to the interlock device, which would prevent a person who's convicted of alcohol-related offenses driving from starting their car without first making sure that they haven't had any alcohol. It's a device that would not allow the car to start unless the person is alcohol-free. I think that's a very good thing. I believe all caucuses have had meetings with MAD Canada, with their representatives here in Nova Scotia, and I certainly did in my first year in office and was aware of this as one of their key concerns, that we have some further measures, that we make use of some technology and further measures to make driving safer for people in Nova Scotia roads. And as we know, the alcohol-related accidents and injuries are very significant in our province, as they are in other jurisdictions. And anything we can do to decrease that is very important, and to also look at the reoffending of people who have been charged more than once with alcohol-related driving offenses. Certainly driving under the influence of alcohol is very unsafe, and this is one way to prevent that recurrence. And I think that it's going to be a good measure. My one major concern, which the minister touched on, was certainly the idea that this be I guess the way that the government has chosen to go is to make it something that a person could do by choice. They could decide to sign on for this program, pay the cost themselves, and have the device installed. I believe that we would have a more effective system if we go with a mandatory system, that we simply say for people who've been convicted that this is now part of your penalty. This is a price you pay for having broken that particular law. Really, when you say breaking those laws, we're saying taking excessive risks and putting other people at risk on our roads. So I would like to see the government look at mandatory rules for the interlock system, and I hope that may be raised at law amendments as well. I'm going to move to the second major clause in the changes to this bill, or the bill that's before us, and that is calling for a doubling of fines in school zones and in temporary work areas on highways for speeding infractions. And I was very pleased to see this come forward today. There are other jurisdictions that have this in place already, and it had come to my attention. I guess I should refer to Monday when I introduced a private member's bill, number 234, which called for a portion of this. It called for a doubling of fines, not only for speeding, but also for failing to yield to a pedestrian in a crosswalk if those offenses take place in a school zone or a playground zone. Now, one of my concerns is that we still haven't covered off playground zones in this, and I think the intent of my bill, number 234, was to raise the awareness of drivers in areas where there are children present. And I think it's really important that that be emphasized. And in fact, the street I had in mind that was in the heart of my constituency is Parkland Drive, which is an oversized street. I guess it's called a collector road. And it has fast-moving traffic. The speed limit is 50, but the traffic is going 70. Racing between Lacewood and Carney Lake Road, and there's no traffic lights along that entire length, no stop signs, nothing to slow traffic down, and there is a playground zone in the Glenbourne subdivision that is along that street. And that is how I became aware of the idea of doubling fines, was from talking to parents who live along Parkland Drive who were complaining about the safety of their children on their way to school because they have to walk along Parkland Drive and cross there. And one resident who spoke to me is in the military and from Ontario, and he told me that in Ontario, where he was from, the signs actually say fines doubled. And he said that sign is attached to the playground or the school zone to say that this is an important area and to really make drivers pay attention. And I think that there's a lot of merit in looking at that at playground zones as well, because this is an area where children are at risk. If I go to the bill itself, we're talking about school zones, and I think that this is again a very, very good forward move for the government to look at doing something to increase safety in the school zones. In Nova Scotia, our school zones have a minimum speed limit of 50 kilometers per hour. So if you're on a busier street, that means the traffic must slow to 50. But that's really not, I think, it's not enough attention to the importance of a school zone. I think that what we want to do in those areas is, again, make sure that the signage on the school zones will actually say fines doubled. Now, I looked into the Ontario situation because it had been raised by a resident in my area, and found that in Ontario, the municipalities have the right to designate community zones. Any community center, any school zone or playground zone, they can determine themselves which ones will have that special status, and they can add those fines doubled signs at their discretion. But I would certainly like to see it on the school areas. Again, this bill has included the temporary work areas or highway construction areas where our workers are at risk, and I think that's another positive step. I had originally put out a press release on just that in the beginning of the school year, which included both of those, where in fact my bill talks only about playground and school zones. I think it's really important that the temporary work on a highway also be covered. And this summer I had the occasion to go to Connecticut for a conference with the Council of State Governments, and noticed all the way through on my drive down through the work zones along the highways and freeways in the U.S., in the states of Maine, and I think Massachusetts as well. There were quite a few of these signs visible, and they really make a difference. And so I think that that will go as well a long way towards ensuring the safety of the men and women who work on our highways and are, as was said earlier, this is their workplace, and they need to be safe. And I believe there was a fatality only last week of somebody, it was in the paper, working on a highway. So it's a very dangerous place to be, and I think it's very important that we follow through and put this in place as well. And I know that the signage will say fines doubled so that drivers know. It reinforces that problem. In the school zones, again, one of the things that other jurisdictions do is actually lower speed limits. And in the province of Alberta, speed limits... Right now? Yeah. Well, just a moment. I believe we're getting close to the time of adjournment, Mr. Speaker, so I would like to with that, see this bill go forward to law amendments. I look forward to hearing from the public, and thank you very much.
Thank you. I recognize the honourable member for Cole Harbour East Passage.
Thank you, Mr. Speaker. Because we're getting close to the end of the time for the day, I'll move adjournment of debate.
Motion is to adjourn debate. Is it agreed? Agreed. All those in favour signify by saying aye. Aye. Contrary minded? Motion's carried. Recognize the Honourable Government House Leader.
I move the House to now rise to meet again on Monday at the hour of 3 p.m. The House will sit from 3 p.m. until 10 p.m. The order of business following the daily routine will be public bills for second reading and Committee of the Whole House on bills. That, Mr. Speaker, I move that we adjourn.
Motion is to adjourn the House till 3 p.m. on Monday. Is it agreed? All those in favour signify by saying aye. Contrary minded? Motion is carried. The House is adjourned till 3 p.m. on Monday.